also are present are other members of the legislature. Mr. Hayden, did you have any thoughts you wish to offer regarding this appeal? I think you had sent me something regarding the Constitution that pertained to whether or not any funds could be actually paid if there was a request for payment of funds, and I think maybe you had discussed, I think Fred, you had a chance to discuss that.
I haven't seen that communication.
Okay.
And I haven't discussed it.
Mr. Chairman, what I had sent to you was a copy of a provision in Article 6 of the Constitution of Missouri that talks about what it's permissible to spend public funds on, and the actual caption is in Section 25 of Article 6 of the Constitution, and it says that no city, county, or other political corporation or subdivision of the state shall be authorized to lend its credit or grant public money or property to any private individual, association, or corporation, except as otherwise provided by law. And I was just suggesting to you that where we're left with here on the Mr. Whipplesfugen's request for reimbursement is that he has in effect requested the county to grant him public money. Mm-hmm. And unless there's some other provision in the law that authorizes that, our grant of public money to him would be barred by the Constitution. Sometimes, you know, we wouldn't be talking about the settlement of a lawsuit because Mr. Whipplesfugen's lawsuit is over. It's a final judgment. The facts involved in that lawsuit are res judicata and can't be litigated again. And so I just wanted to make sure you and then the members of the committee were aware of that constitutional provision, because I believe it provides a significant hurdle to any consideration of a payment of any sum to Mr. Whipplesfugen.
Okay. Now, does anyone have any questions about what has been, at least what Mr. Hayden has indicated regarding the Constitution?
Yeah, Mr. Chairman.
Mr.
Yeah, Jay, I hadn't heard that before. That was new to me, and I never got a communication on that.
Well, I apologize, Mr. Urbanus. Yeah. I thought that you and Ms. McQueenie had a brief conversation about that last week, and I know that there had been some discussion of securing some independent legal advice, and I know you mentioned that last week, and I had thought that Ms. McQueenie had mentioned that to you in connection to that discussion. And if she didn't, I apologize.
Yeah, Dan Tarwater, he mentioned it to me last week after the meeting, and so, you know, I guess he was up to date on that, but I wasn't briefed on it. At least I don't remember it, and that's one of the reasons why I brought up the subject last week, is because this, you know, fellow's been in front of us several times, and we're all very sympathetic to what happened, you know, to his daughter, and you know, I didn't know where we stood. You know, he's appeared in front of us. We keep getting communications. You know, is there something we can do? Apparently, you just said that there's nothing we can do, and I can accept that, but I don't know if other legislators are going to accept what the county councilor says, and that's why I think it's probably a good idea, if some of the legislators still feel that way, it might be a good idea to get an outside opinion. And that's why I mentioned Mr. Fritkin, because I've got a lot of respect for him. He's one of the fellows that wrote the charter. He's been called in several times in the past to give an opinion, and he's somebody that you know, he wouldn't have to get himself completely briefed over a situation like this. He would probably be able to get it done fairly fast.
Well, I think what you were describing or discussing was whether or not he could be paid anything.
Correct.
Right? I mean, that's one part of the question. The other part of the question, as I understood from our discussion, was whether or not he can, in fact, appeal whatever the Office of Citizen Complaint decided here, as far as what he had brought to them, and which would necessitate a review of what their decision was by this body, absent whatever he litigated in costs, attorney fees, anything else. And my understanding is, from looking at it, from what our discussion was, he still had, even this amount of time later, the opportunity to bring that decision here under the current status of the ordinance.
In the ordinance, there is no time limitation on the time in which Mr. Whipplesfugen could appeal that. Actually, what the language, and if I might read the ordinance actually into the record, Mr.
Is it very long?
No, it's about 5 lines.
Okay.
Any citizen, county official, or employee who feels aggrieved by an act of the commission, and that's the OHRCC commission we're talking about, may report such an action to the county executive or the legislature. Any act of the county executive or legislature contrary to the recommendation of the director or the commission shall not reverse or nullify the commission's action, but shall stand as advice to the commission. And that's section 7409.3 of the code, captioned appeals from the commission. So the title is appeals, but the language the ordinance text actually uses is report. So the situation you've got is that Mr. Whittlesey has reported the action of the commission to you and has asked you to take it up and make a recommendation or give advice to the commission on whether you think they were right or wrong. And that is, your right to do that is not restricted by time in the ordinance, so you can do it now.
If I understood what you just said, if we gave an opinion to the commission, it would not necessarily even be with the strength of an appeal. They could still remain with the decision they have.
Right, correct.
We just simply say, well, we think that perhaps you were wrong for these reasons, and they would not be then required to change their opinion or anything else of that nature, right?
Correct, Mr.
So
Chairman.
it's not really an appeal of their decision, actually, is it? It's kind of a review of their decision with no potential impact if they don't care to let it have any impact on their decision.
That's correct, Mr. Chairman.
So what's the point?
Well, I don't know if that's the question for me.
Yeah, well, that's the question. I mean, if we're not going to have the ability to reverse them or modify it or whatever else, and then a person can do it at any time. It occurs to me maybe there needs to be some time frame where a person, if they are aggrieved, they have to go ahead and appeal if it's going to come here to the executive, and then maybe there needs to be something that says that we can do something, But at any rate, that's what we're dealing with, it seems to me. First of all, is there some kind of, would the legislature be interested in reviewing this matter for some kind of advisory kind of opinion? And second of all, there appears to be a question as to whether or not anything could be awarded financially. Does anyone have any other thoughts on this right now? I mean,
Mr. Chairman? Yeah. Mr. Hayden, is the time for appeal by either side finished on the actual case, the Sunshine Law case?
Yes, it's a final judgment, Mr. Chairman.
And it's non-appeal?
Not appealable.
Okay. Why can't it be appealed?
Because the time has run for filing a notice of appeal.
Okay, when did the time run on the time to appeal?
Some time ago, weeks ago.
Okay, so there's a set 60 days after the decision or something like that?
I don't have the exact dates, but it's well past. And I think Mr. Whittlesey, you're going to correct me if I'm wrong, I think he may have even said that to the legislature the last time he addressed the legislature.
Right. Well, Mr. Chairman, I think what's troubling about this case is I don't believe the county in court made it very clear to the judge that Chapter 16 indemnified the board. So I think the judge was under the impression that he would be personally assessing it against the board commission members. Whereas if somebody's on the planning commission or this body or anything else, they know that if a developer gets angry and sues them personally and the county or whatever circumstance, that the county is not going to leave them hanging. I think in court, the counselor's office didn't make that very clear, and I think stayed mute on the point. I think the broader policy issue is this where we want to leave the Sunshine Law? Do we really want to leave this way, that somebody who was upheld in court in 4 of 7 counts has to go at their own expense, and then they're left as a treat with that expense? And I think we almost have to review, what did the county do in court? Why did this case go on for 2.5 years? Was that deliberate? Is that how government is handled now when a citizen has a point? And clearly, when the judge rules in 4 of 7 counts, there were some at least obvious technical problems with the Sunshine Law. The judge didn't hesitate in his ruling. And when that happens, why didn't 2.5 years ago somebody say the county's at fault and settle the case? Instead, the counselor's office, I assume with the concurrence of the executive, proceeded with this case for 2.5 years. And are we going to leave the Sunshine Law that way, that yeah, we talk about open meetings and we talk about open government, and the Sunshine Law really isn't for the fourth estate or the press. It really was designed for people. And are we going to leave it that way, that a citizen does all this stuff and then is just left with the bill as the reward. And doesn't that, in effect, make the Sunshine Law meaningless? That when somebody has a grievance with their government, they follow all the procedures, they follow the charter. When that board makes mistakes and they file a suit under the Sunshine Law and they're upheld,